As you all know, a judgment pronounces the judgment and the verdict is announced by the court. Judgment means the statement of a judge of the grounds of decree or order. So these grounds are gathered from the evidence of the parties. The court digs out the realities, finds out the facts from the evidence of the parties. So the evidence of the parties is very much material for the determination of facts by the court. So evidence under Article 18 of the Qanun-e-Shahadat Order 1984, evidence may be given in any suit or proceedings of the existence of a fact at issue or of relevant facts. So the evidence is gathered by the parties and produced before the court for the purpose of coming to a conclusion regarding the facts at issue. So all those facts which are relevant for the purpose of determining the fact at issue are part of evidence. So what is relevant? Relevant means any two facts to which it is applied are so related to each other that according to the common course of events, one either taken by itself or with other facts proves or renders probable the past, present or future existence or non-existence of the others. So this definition of relevant is a broader one, but Qanun-e-Shahadat gives us certain facts which are relevant, and the definition given by the word relevant is not so widened in the Qanun-e-Shahadat. Qanun-e-Shahadat gives that those facts which are declared relevant in Qanun-e-Shahadat are relevant, all others are not relevant, in spite of the fact that others are also relevant, but those cannot be treated as relevant because Qanun-e-Shahadat does not allow us to treat them as relevant. So there is a distinction between the logical relevancy and the relevancy provided by Qanun-e-Shahadat. But we are to confine ourselves for the production of evidence only those relevant facts which are provided as relevant under Qanun-e-Shahadat. So the evidence is given. Now the question is, who will start the evidence? Who has a right to begin the evidence? So for the purpose of determining that who has a right to produce evidence first, we are to see the fact at issue. When one party asserts a fact, other party denies thereto, a material proposition arises therefrom. So material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute a defense. So the facts constituting the defense and the facts constituting the attack, when they are contradictory, they give rise to a material proposition. In the simple word, we may say that when one party asserts a fact, other party denies thereto, a material proposition arises therefrom. That material proposition is a fact at issue. So the party is to give the evidence on the facts at issue and all those facts which are relevant for the purpose of determining it. Now when the issues are framed, the burden is determined that who will prove the issues, what issue will be proved by whom. The plaintiff will prove certain issues, the defendant will produce certain issues and presume them and then prove them. Now for the purpose of determining that who will give it, Qanun-e-Shahadat gives the way and methodology to prove how the party is to prove a fact at issue and who is bound to prove it. So the party who is bound to prove a fact at issue is called that the onus probandi is on that party. So generally, when a party asserts a fact, he has to prove it. So when there are issues giving rise to certain assertions, the party who is asserting shall have to prove it. Now the right to begin is on the party who is to prove the fact at issue, and onus is on him. Suppose there are two issues. The onus probandi of both the issues on the plaintiff. The plaintiff shall have a right to begin. He shall make a statement, he shall produce his evidence, and he shall conclude the evidence on those issues. Then the defendant shall give the evidence of rebuttal. Firstly, the plaintiff shall state his case and then produce the evidence, because the onus probandi of both the issues on the plaintiff. But sometimes it happens that the burden of proof is not on the plaintiff but on the defendant. If there is no issue, the burden whereof is on the plaintiff shall not begin. It is the defendant who shall start, who shall have right to begin the evidence, because the onus of all the issues is on the defendant. So the determinative factor is the onus probandi. If the onus is on the plaintiff has right to begin. If there is no onus on the plaintiff and the onus is on the defendants have right to begin. The party starting shall assert his evidence as he is asserting the allegations in his plaint or written statement. And then when he shall be doing that, after that he shall state its case as a whole. Then the other party shall have a right to rebut it. If the plaintiff starts, the defendant shall have a right to rebut. If the defendant starts, then the plaintiff shall have a right to rebut. But there are certain conditions when there are several issues, as in is given under Order 18, Rule 13. Order 18, Rule 3. Evidence where several issues. Where there are several issues, the burden of proving some of which lies on the other party, the party beginning may, at his option, either produce his evidence on those issues or reserve it by way of answer to the evidence produced by the other party, and in the latter case, the party beginning may produce evidence on those issues after the other party has produced all his evidence, and the other party may then reply specially on the evidence so produced by the party beginning. But the party beginning will then be entitled to reply generally on the whole case. The right to begin is determined by the provisions of Rule 1, who has a right to begin. Rule 3 lays down the procedure to be followed in a case where there are several issues. So how it is determined? If there are several issues, the burden of some of the issues is on the plaintiff and the burden of some of the issues is on the defendant. Now first of all, it shall be seen that the plaintiff has a right to begin, whether he gives evidence as a whole or if he gives evidence on those issues, the burden whereof is on the plaintiff. If he chooses that he shall give evidence on those issues, the burden whereof is on the plaintiff, he shall give evidence on those issues and reserve the right to rebut the evidence of the defendant. Thereafter, the defendant shall give the evidence on those issues, the burden whereof is on the defendant, and also rebut the issues, the burden whereof is on the plaintiff, meaning thereby that the defendant shall have to lead the evidence on all the issues. On some issues he will produce the evidence in rebuttal, and on some issues he will give the evidence of affirmative. Now he has given the evidence of affirmative of those issues the onus whereof is on the defendant. Now the plaintiff again comes to rebut those issues. Those issues are rebutted by the plaintiff. The plaintiff shall rebut the evidence, the issues, the burden whereof is on the plaintiff. So meaning thereby that plaintiff has to give evidence twice. First he shall give evidence on the issues, the burden whereof is on the plaintiff. Then the defendant shall give evidence once. He shall have the right of rebuttal and affirmative evidence at one and the same time. He shall give the evidence on the issues, the burden whereof is on the defendant, and he shall give the evidence in rebuttal on all those issues, the burden whereof is on the plaintiff. But once his evidence is closed, then again it comes the turn of the plaintiff, that he had given the affirmative evidence when he had a right to begin. Now he has another opportunity, another right to rebut the evidence of the defendant on those issues whereupon the defendant gave the evidence. So this evidence is examined in the open court. Order 18 Rule 4 says that the evidence shall be recorded in the open court. The court is open for the purpose of recording the evidence.